Hello, everyone. Good afternoon to you all. Our numbers are still low, so we are waiting for others to join. You can actually share the link with people so that they also join. We'll start in about 5 minutes time whilst we wait for others to join. Hello, once again. So, on behalf of the Institute of Sustainable Design and Construction Management and the Architecture Alliance, I warmly welcome you all to today's webinar. We are excited to have you join us for this session, which will be on professional negligence, where we get to understand the duty of care as a construction professional. For those of us here, kindly share the link with others so they can also join us. We'll be starting from now. So we have some sponsors that actually sponsor this webinar, and I'd like to acknowledge their presence. We have EAP Consults, Liando Africa Attorneys and Consultants, Terry Norman, and Simaf Gold Limited. These are our sponsors that made it possible for us to bring this webinar to you today, as well as Multibuild Limited. So for now, I would like to invite Okay, sorry for that. So this is the program lineup for today. We'll be having the opening remarks by Miss Edith Asama, the Director for CSR on projects. From there, we'll introduce our speakers who will take us through legal foundations of professional negligence, practical applications in construction industry, risk management and practical guidance. Then we'll have the interactive poll. After that, we'll have the questions and answers, then the closing remarks, then that'll be all. So I would like to introduce Miss Edith Asama, the Director for CSR on projects, to give us the opening remarks. Miss Edith, over to you now.
Thank you very much, Theodora. We are all officially welcome to today's meeting. I am excited. I don't know about you, but I'm really excited to get to hear all that is going to be said about the legal foundation of practice and risk management. Like Theodora said, my name is Edith Asma, not Asima. My name is Edith Asma. I'm the director for the CSR for the Architecture Alliance. I would like to shed a little bit of light on what we do. So Architecture Alliance is a collaborative platform where we unite architects, urbanists, spatial thinkers, in rebuilding our environment more equitably, more sustainably, with an inclusive future. We are a very purpose-driven architecture initiative platform where we believe that the power of a building changes life. It just goes beyond giving shelter. It seeks to give a place of security, a place of healing as well. And our mission basically is, we're very simple but very ambitious in our dealings to design and construct very essential buildings for our community. And it's basically funded by people who care. So we care about our environment and we care about every little detail that goes into making it very sustainable. Hence, this webinar is actually very close to our hearts. And we hope that by the end of it all, each and every one of us will take something good with us in our practice. Thank you very much. Theodora, over to you.
Thank you, Edith. So now I'll call the Director for the Institute of Sustainable Design and Construction Management, Mr. Charles, and Mr. Compson, to also give us his remarks before we begin this session.
Hello. Yeah, so welcome everybody, construction professionals, to this platform. The Institute of Sustainable Design and Construction Management is also a professional body of construction management professionals where we engage on regular basis to discuss issues affecting construction. So this is, I think, for this year, our first webinar, and we decided to talk about professional negligence, a topical issue now. Clients are getting, let's say, wiser by the day. Buildings are collapsing. Whose fault is it? Is it the architect, the engineer, or the contractor? We need to understand what we mean by professional negligence. So thank you for showing up. We are grateful. We have 83 people on call. We are trying to share a Facebook Live as well because we are sure we are going to go over the 100 maximum that we have. So thank you for coming on board. And you can pay attention to the seasoned speakers we have, and you can ask them questions. They are ready to listen to you. Thank you very much.
Thank you, Mr. Charles. So I'll go ahead to introduce our speakers for today. For today, we are honored to be joined by two distinguished speakers, Lilian Geraldo, the founding partner of Liando Africa Legal Consult, and a legal professional with extensive experience in energy, infrastructure, corporate governance, and project consultancy. She'll be taking us through the legal foundations of professional negligence. So, Lilian, please, you can take over now.
Hello, good afternoon, everyone. can you hear me? Please confirm by giving a thumbs up if I am clear. Thank you very much. So thank you for the opportunity. Like Edith rightly said, my name is Lilian Geraldo. I am with Liando Africa Legal. We run a very contemporary practice somewhere in Kanda. And amongst other things, we do consult on construction or development infrastructure projects. So for today, we are going to go. I don't know. I wasn't advised as to time. Can you quickly confirm for me how much time I have so I can, streamline the.
We have 15 minutes, so we can.
15 minutes. Okay, this is literally a marathon. So we are going to run as fast as we can. And I'm going to share with you as much as I can. And I think that the main takeaway for me and what I would commend the organizers on is the fact that we're having these discussions with the actual professionals, because usually at the dispute level, we tend to see the client or the employer or the counterparties to the agreement, properly so called. Whereas, for instance, the incidences that bring about these situations that we're about to discuss are usually on the ground at the surface level or with those of you here. And so I think that it's very important that we are all guided as to how we contribute in our employer's liability, on the grand scale of things. So we'll quickly run through the content. We'll discuss the legal foundations of negligence or professional negligence, properly so called. We'll understand what negligence is. Then we'll speak also about the relevance of this study, which I have touched on a bit in my introduction. We'll conceptualize negligence. I think for these ones, because they're a bit theoretical, we will just quickly run through them. And then we'll discuss properly what professional negligence is, for which we all have to be, ready for. And then we'll look at the test for negligence, that if in such scenario, how do we establish it? And then the legal concept of duty of care. Then we bring it back a bit into the Ghanaian context, or how it relates to us, or how the Ghanaian law treats this kind of situation. And then we'll also discuss, also importantly, the standard of care. After which we'll look at the requirements for establishing a claim, which is what's usually, for us, the lawyers, we would usually, play a role in. And then we'll look at, where the liabilities could come from, whether through contractual obligation or in a general sense, a tort liability. So if you would assist me with the slide, we'll just run through this. So starting off with negligence, we need to understand what negligence is. And being of a common law jurisdiction, what it simply means is that most of our laws were translated initially from, the English law. It means that for most of these concepts or phenomena, it's just English. So don't think that it's a very, negligence is a legal theory, for which reason it will be hard for you to understand. It's English. So if you look at negligence as a noun, it simply means a failure to exercise the level of care that a reasonably prudent person would, in similar circumstances, a failure to exercise the level of care that a reasonable prudent person will do in such circumstances that will cause an injury or harm. And then if you look at it as a verb also, it means to act or fail to act in a way that falls below the standard of reasonable care expected, thereby causing damage or risk of damage. And why this is important for us to know is that usually when the claims do come up, you may be sued, or your employer may be sued for negligence in a general sense. And you may also be sued for having conducted yourself in a manner that is negligent. So for instance, when it comes to, and then I'll take this at the employer level, it can even have to do with termination of a contract. You can terminate a contract negligently. You understand? For which reason you will be held accountable for negligence. So those two dynamics really come at play, especially at the dispute resolution level. So it's important. The relevance of this study is for us to all appreciate and understand the role we play, or how we contribute to these liabilities. And it's very important. And one thing I always say is that as professionals, we do not act in isolation. We are not islands. So for instance, if it's you are a road contractor, the supplies person, the QS, all of you are contributing to the success of the project. So you don't act in isolation. You don't do your work in such a manner that would, cause a harm or would have a negative impact on your professionals' work. And usually that's what happens. And that's what happens. So you find out that on the grand scale of things, all these petty interactions, us failing to really have a correct synergy with work, will contribute to our employer's liability. And so we need to know this so that we are able to be guided in our expectations, in our representations, in our interactions, and then in the execution of work. And if I say representations, for instance, I'm working on this power project, and we are currently at the funding stage. So we are trying to raise equity. We have a very ambitious financial close, which is towards the the end of Q3. And just yesterday, we had to terminate a contract of one of our fund hunters because they had made certain representations that did not mirror the reality, and for which reason we've had to incur additional project costs, like on the entire project. So with some of the representation is the company's contract that we have terminated, but it's someone on there that made those representations. So we need to be very guided in how we do these things and how we execute the work, because most of these construction projects, they involve numerous risks, including physical hazards and complex legal obligations, whether you like it or not. And so it's important that we learn how to mitigate these risks at the grounds level, and safeguard the well-being of all parties involved to ensure the integrity of the project. Okay, because if we fail to do so, it can lead to severe legal repercussions, and that's where we come in. So the next thing we are going to discuss is negligence as a tort in a general sense of view, which is personal injury, and then professional negligence. When we talk about tort is simply an injury to a person that from which the victim can make a claim or for the liability. So for tortious offenses, we can have even assault. So if you want to, it's the opposite of crime, basically. For crime, it's the state that will prosecute. But when we want to talk about civil liability, if someone assaults, you can sue them actually to recover money. Do you understand? So when it comes also, so negligence is one of those things, that there's an injury to a person from which the person who is so injured can make a claim for liability from the defaulting party. So I will not mention the case law because I think the slides will be shared after this, so you can take a look at it properly. And then we come to professional negligence. So in the general sense, negligence is the omission to do something which a reasonable man, guided upon those considerations which ordinarily regulates the conduct of human affairs, will do, or doing something which a prudent and reasonable man will not do. It means that we are acting outside of what we would legally situate as a reasonable man, and we'll come to that. So when it comes to professional negligence, we are speaking about where a professional, like many of us here, or maybe all of us here, who holds themselves out, that's also very important, as a professional or as possessing special skills, fails to exercise the level of skill, care, and diligence reasonably expected of a competent professional in that field, resulting in damage or loss to another party. So for instance, if you are for a quantity surveyor, or let's just say you're a site supervisor on a road project, and you know that the highways people are coming to take their measurements as to whether or not you've been able to satisfy their requirements per the construction project, whichever project it is that you are handling, and you make errors in that, for which reason you understate or you overstate, and there are damages, or there are, your employer or whoever the case is suffers some default on your account, you can be said to have been in default of the professional negligence or the professional duty or standard expected of you. So that's generally the idea, that you are holding yourself, you're a professional first of all, and that you are holding yourself as having possessing some degree of skill at whatever work that you are doing or engage with, and you fail to exercise at least the standard required of that profession, and there's a resultant damage or a resultant loss out of it, then we'll say you have been found professionally negligent. So when we talk about the test of negligence, there's a case law that it's just failing to do what a reasonable, ordinary, skilled man will do. So it's not to suggest that you have to be the perfect or most, renowned at the game or at whatever that you are doing, but it means that you should be able to at least demonstrate some degree or some standard or some skill in whatever field that you find yourself. If you're into block work, and at least we can all appreciate that when it comes your alignment and everything, it has to be straight 90 degrees or whatever, then you will not go and be given otherwise. That's like the most basic of you, that if you're doing block work, for instance, the walls must be straight. And I'm trying to make this as relatable as possible. So if your walls have to be straight, then it just has to be straight. You don't need to be, of a certain height or anything to demonstrate that. That's just simply what it is. So when it comes to professional negligence, properly so-called, what we need to really understand and appreciate is that you have a specialized knowledge, right? And based on your representation as to having had that specialized knowledge, your client or your employer or whoever you are going to hand, if it's a turnkey, whoever, the client is or the employer is, at the end of the day, you are going to hand over, has relied upon the fact that you have this specialized knowledge or skill. And then it also requires you to make some professional judgment as to how you go about in the execution of whichever work or task it is, per whatever arrangement you have or whatever contract or whatever you've been engaged to do. So when it comes to professional negligence and in making a valid claim, I think this is also very important for us to note, is that we need to know, for instance, so the next slide, that there is a duty, you need to establish that there's a duty of care, and based on that, there has been a breach. This is where you've committed that act or omission, where there's a breach. And then we also need to establish causation. There has to be a causal link. So act and then effect. Act and then effect. So whoever is making the claim in respect of, they need to establish, for instance, that it is through A's work or through A's business, or it's because of, on account of A's failure, that I have suffered this loss. So there's that causation there. You need to establish a causal link, and the causal link must be continuous. There shouldn't be a break. You understand? So for instance, if let me bring it down to like the residential level. So we have an electrical, the MEP people, they've done their everything, they've connected their cable somewhere in the ceiling or whatever, and we have somebody who is in charge of the plaster boards and everything, and there has to be a revision work or something of the sort, and you go about cutting willy-nilly without recourse or without the due notice, or without making sure that your co-professional is aware or has had some input in whatever you are doing, which is affecting their work, and there is a resultant loss, for instance, that there has to be some remedial action taken by the owner of the property per se, who in attributing who did what, we need to be sure that it's certainly the actions of the electrician that has caused the loss as to the plaster guy's work, without any interference. So if somebody else came in there and also assisted in the work, or, ruined the causal link as I have properly described, then there may be an issue in establishing or making a proper proof, or, generating that proof or that belief that indeed is whoever should be held liable should be the electrician and not otherwise. So that's what we call the causation. And then there has to be actual loss or damage. So we need to be able to assess that based on A's action, B has lost or B has incurred liabilities to the tune of $1 million, to the tune of $200,000. We need to be able to see, and then we'll be able to identify and isolate and then make a valid claim. And then when we get to on that degree where, for instance, we've been able to identify that there is actually a claim to be made premised on negligence. Usually what you need to, the chain of events is that the victim or the one who has incurred the loss will make the claim, establishing all of these things that we have mentioned, that there was a duty of care, there's breach, causation, etc., actual loss. Then they will have to prove it. And proof also requires some sort of evidence. And with this, we cannot underestimate the importance of record keeping. I'm sure my other colleague will touch on that when it comes to the practicality of things. But record keeping, I keep emphasizing on that. You cannot underscore or you cannot underplay the importance of record keeping. So if you don't have, even for us as lawyers, we have in my office, we have a law firm management software called ClickLaw that we usually use in reporting, and it has multiple use. But now the technology is there for you to be able to keep track of whatever happens on site. There are cameras and all of that. And with the cameras, I keep talking about, you cannot, somebody has to man the camera some way, somehow. And it helps in mitigation. So it's not the case that we put the cameras there for, for the beautification of the site premises, but for, proper checks to make sure that at least if there is an incident that is bordering on the negligence or otherwise, or one of the artisans or the workers on site, then something can be done almost immediately to mitigate. And then also in such scenario, you also look at the possible defenses that may come up, and then we talk about the compensation or damages. So the damages can come in various, it can be like direct, which is the general damages, and special damages where you would have to actually again show some.
Well,
sorry, please, if you can mute the person. So now we are going to move into the legal concept of duty of care. And this is also very important. You all need to identify ourselves within the chain of events, where we stand. Because sometimes we are not the ones that sign the contract, but our actions read into the obligations of the counterparties to the contract. And so the legal concept of duty of care is the legal obligation imposed on professionals to act with reasonable care so that their actions do not cause foreseeable harm. So it means that whether you like it or not, whether you were there in the boardroom when your employer was signing the contract or not, there's a legal obligation imposed on you to act with reasonable care so that your action will not cause foreseeable harm. There's a case called which brought about the neighbor principle, and I've already touched on the fact that we do not act in isolation. So for whatever activity you're engaged on in site, you need to envisage that it will affect this person or that person, and that's what the foreseeability is about. So in the Caparo case, the court sets down the 3-stage test that for us to be able to say that indeed there was a duty of care, you need to have had some foresight that your actions would have caused this reaction. And that's the foreseeability context. There must also be some proximity. And the interesting thing about these kind of scenarios is that sometimes it's not only us between, the players at sites, etc. You may also owe a legal duty to even third parties, or for instance, the general public at large. So if you do and I'll give a typical example. Even when it comes to, the building regulations and stuff like that, for site areas around site, you are supposed to, for instance, ensure that traffic is not hindered by any, so you're supposed to manage traffic, right? So in this case, then it means that the general public, if somebody, is able to establish that in your failure to do what you were mandated to under the regulations, etc., it has caused them some harm, and is able to establish all these things that I've already made mention of, then they can make a claim against you. So there has to be some proximity, and with the proximity, we are trying to say that there should be a relationship that should be sufficiently close. There should be a relationship that should be sufficiently close. And then we also look at what is fair, just and reasonable. So it's not as though third parties or busybodies, as we call them in law, like everybody can just stand up and make a claim or make an allegation against you for having acted in such a way that has caused them a loss, for which reason you have to compensate them, right? So moving forward, we are going to look at the Ghanaian context. When we are talking about the duty of care and professional standards, what really does the Ghanaian law say? And with that, to be very frank, apart from, I mean, aside or away from contractual obligations, we have the Architects Act and the Engineering Council Act that gives us an idea as to the expectation of professionals. So, for instance, in the Architects Act, it says that only registered architects may practice as architects. And that's also very key. So that if you are to hold yourself as a practicing architect, it means that you ought to have been registered, so that if there's any issue and we are going to hold you accountable for, it wouldn't be the case that, for instance, you were not properly, inducted into the industry or whatever the case may be. The Engineering Council Act also, which is a bit more fairly recent, also indicates that a person shall not offer engineering services or practice engineering unless that person is registered in accordance with this act. So you don't hold yourself out as an engineer for there to be an issue, and then you come and say that, for instance, I am not, you cannot put me in the box, or you cannot have an expectation of me to act professionally because I was not. Per these acts or this enactment or these legislations I've referred to, then you would have been found wanting, and how do you call it? Disciplinary action can be taken against you. So please, let us be guided in how we hold ourselves out and how we represent ourselves in whichever field that we find ourselves. So then we'll then look at also in the duty of care. In the duty, when we are talking about the duty of care in construction projects generally, it may exist between, for instance, a professional and a client. So whichever professional you are and the client, either of you can hold each other accountable if there's any negligence on your part, right? And then also in terms of a consultant or a contractor, and I'm sure a lot of us are very familiar with some of the consultants that we work with. Some of them may not even be, on the ground like that. But if there's any issue or if they act in such a manner as to, occasion the harm that we've already talked about, you can make a claim against them for negligence. And also in respect of a contractor and an employer, depending on whichever contract or regime of contracts are coming under, and then also professionals and then the end users of the building. So there are certain persons. So if you, for instance, an engineer designing a structural component of a building should know that beyond the contractors or the co-work colleagues on site, the end user will be the public. If it's a civil infrastructure project, the end user is the general public. So you don't design a bridge without considering or factoring in safety elements. So that, for instance, we have a footbridge and part of it is falling apart, and the general public, a member of the general public, gets injured. You come and say that, for instance, you didn't sign a contract with them. Your contract was with the government of Ghana, so they cannot do anything. That is a complete lie. You can be held liable. So we all have to be very, very guided in this. And so if you know that your design is effective or defective, you should be prepared that foreseeable harm will arise. And so you have to be careful. And then we'll also look at the standard of care required from construction professionals. What is the requirement? The standard, as we have explained. So there's an authority on that, I'm sure, which is Boland versus Firing Hospital. And that what it literally says is that a professional is not negligent if their conduct conforms to a practice acceptable as proper by a responsible body of professionals in that field. So if you have, like, for the instance, at Roman Ridge, we have the Ghana Institute of Engineers. So if they put together, some standard as, how do you call it, a practice that is accepted, then if you act in line with it, nobody can hold you accountable if you act outside of. So the most important thing is that you also always make sure that within your professional field, whatever the acceptable standards, both local, especially local and universally, you are always compliant. So for instance, if you hold yourself out as having a particular professional qualification or competence, you'll be held to the standard and skills of a person in that position. So for instance, my brother is an architect, and we have on site, we have interns sometimes from the schools. come in and they are working with the company, and maybe they may have to do site visits and everything. So if the intern or the national service personnel in the firm conducts itself in a way that when we are assessing how to determine the standard, and mind you have to be careful with these people also, because sometimes they do put you in trouble. But in such situation, the standard we'll be expecting from them will not be as though it's a professional. But mind you, there's also vicarious liability and etc. That, for example, if they're acting under your instruction, so that is a conversation for another day. But just to explain what the standard is, that is, I think, a very simple example of such situation. So a junior or inexperienced construction professional will not be given a lower standard of care by reason of incompetence. You understand? So in that instance, how do you call it? Whoever they are deriving authority from is who will use to measure. I hope that is clear. So the standard is that the standard test for that will be of a reasonably competent professional, regardless of your years of experience. And failure to meet these professional standards that I've mentioned earlier may constitute negligence. That's just what it is. Failure to meet the standard required of you. It's simply negligence. And so when we are making professionals liable for construction defects, it is in situations where there are errors, there are omissions or negligence acts. For instance, a negligent design that has caused property damage or bodily injury, or in the most common case, financial losses to the clients or to the employer. Yeah. So when it comes to what's the requirements for all of us, or for all of us as professionals, it means that we have to exercise competence, we need to exercise reasonable skill, we need to exercise proper diligence in the way we coordinate ourselves and our subordinates on site. And also, we need to be compliant with the accepted professional standards. Yeah. And in assessing the standards, usually when the courts will have to, assess what degree should we credit to whichever standard you have demonstrated by your work, in determining whether or not you are truly negligent or not. We'll be looking at professional regulations, industry codes, your professional guidelines, for example, established construction practices, which is also very key. So in this particular industry, how do they do their things? How do they conduct their, what are the terms of trade? What is the usual practice? Those are the kind of things the court will have to assess. And then sometimes we may have to even look at expert evidence from other professionals, depending on which degree of infrastructure it is, because we know that in certain jurisdictions, they are known for certain degrees of infrastructure. So we may want to get an expert's opinion on whether or not you've exercised that degree or that professional standard of care, for which reason we should determine to what degree you may be negligent or otherwise, right? And then now we are going to look at the relationship between contractual obligations and tort liability. I explained earlier briefly what the tort is. So it's just a civil claim for bodily injury or harm, for which allows the victim to be able to make a claim for whatever loss or damages they have, how do you call it, incurred on account of your actions. And so when it comes to negligence, generally so-called, sometimes the person making the claim can make the claim based on a contractual promise that you made that you did not see through. So for instance, if you make the promise that in putting up the infrastructure, you shall exercise the degree of, sometimes they are in the terms, that's, the standard or the best professional standards of the industry, or as your industry will dictate, and you are found wanting, as in you are found to not have acted in such manner, then we'll say based on the contract you're in breach, therefore you are negligent. So that obligation, or that situation that will give a claimant the right or a power will be from the contract, and it's usually for breach. And then in tort, which I mentioned earlier, as for instance, when I was making the case as to third parties even making claims, or end users of a project making claim. It means that if I don't even know, I'm a Ghanaian citizen that has, has suffered bodily damage based on some project done elsewhere. I was not a counter, I didn't sign, I wasn't there when they made the agreement, but I'm able to demonstrate that they failed to exercise reasonable care or the standard of care. And I'm always established that they owe me a duty, even though I'm a member of the public by nature of the contract or the construction, the project they were undertaking, then I can make a claim under tort for it. So sometimes there's an overlap. Sometimes there's an overlap where it can be either way. So that's what we term, as you can see in the chart, as concurrent liabilities. So that is where, I mean, it's for us to figure out really how to place. For instance, if I'm representing a claimant, then it is my duty or my responsibility to be able to demonstrate or to be able to tell the court or the tribunal, whichever the case may be, if you are doing arbitration or we have to go litigation properly so-called, or if you are doing an internal adjudicatory exercise. For instance, if it's a FIDIC project and we have a DAB or a DAB in place, or maybe we have an engineer as, as a piecemeal, as a dispute resolving authority or something of the sort, and we're going to make this case. It's for us to be able to identify exactly where we stand and then advance the case, whether or not where we are deriving our rights to make such claim is from the contract or in torts. Yes. And then also, if you look at the contractual liability properly so-called, it's usually contained in the consultancy agreements, the contract, the construction contracts, whichever type of contract it may be, and then also from professional service agreements. Yes. And then with the torts, is very open. It arises independently of the contract. So even where there is no direct contract, liability may arise if your negligence will cause some degree of loss. And when it comes to the contract liability, some examples of the contractual liability, some of the examples are failure to deliver drawings on time. So generally failure to meet timelines. So if you have a completion date, for instance, of maybe December 2026, and you have mismanaged, the time schedule or your work plan or your work schedule so much so that there may have to be an extension or anything. So if that would have a negative impact or a negative financial impact on your employer or your client, they can, make a claim for negligence against you. And then failure to supervise works as agreed. As agreed means that there was a contract for you to be able to supervise work or failure to meet agreed specifications. And this is very key. I keep highlighting on the importance of keeping records because sometimes things may get lost in translation. So if there are specifications that have been agreed to, not even at the contractual level, but at least, on the engineers and the interaction with the architects, etc., and you fail to meet whatever specifications. And I think this is very serious because sometimes even the integrity of the project may even be compromised. And so it's very important. So if you fail to meet agreed specification and it results in some damage, especially if it's a financial loss, then you will be held to account for that. So let's all be minded in respect of these things. So, for example, if a structural engineer a structural engineer may be liable to a property purchaser who relied on the safety of a structure, even if there was no direct contractual relationship. I hope that is clear. So if you are the structural engineer that worked on a particular project, let's say, for instance, this is a residential facility, and you dealt with the contractor, you dealt with the owner, and they've even sold it off to a third-party buyer. And the ceiling comes down one day when it rains heavily because, for instance, you didn't factor in the gutter pipes, for instance, and your design was that defective. Then you can be held liable by whichever person it is, the purchaser of the property is. So when we are applying ourselves to or applying our skills to whatever project we are undertaking, it is very, very important that we are able to exercise that degree of stuff. The whole essence of this is to just do your job, really, sincerely speaking, is to do your job in such manner that is expected of you. That's simply it. So if you're a competent architect, just do what a competent architect would do, being minded by the other interlace or the other interfaces or the other interactions you have with the other workers who are also contributing to the project. That's simply what it is. So just do your work and do it properly, do it professionally, and at the end of the day, you don't find yourself in a situation that we have to have to go back and forth with. There are lots of instances where we've been to court. Usually, even with the highly incentivized projects, we usually do arbitration, etc. So sometimes we may have to go to the London Court of International Arbitration. There are quite a number of them. The Ghana Arbitration Center is there. The Ghana Institute of Engineers. They also have an arbitration center. I'm well aware. And sometimes it's the most ridiculous thing. And usually when we have even the actual worker that acted so negligently that has occasioned the loss may not even be, because it will be his supervisor that may come and testify on his behalf. And you find that with some of the resultant losses that the project will incur, or how much the project expense will have to have been expanded or reviewed upwards because of some very, very tiny thing, you realize that if we were really, really being diligent and exercising that degree of professionalism that is expected, we will not have to deal with all of these things. And having to resolve disputes also comes at an added expense. So why would we have to put ourselves through this? Why would we have to put our employers through this, or those who, have brought us onto the site? So as much as possible, and I'm going to conclude here. Let's all try, be very familiar with whatever our professional standards, whichever industry we find ourselves in, or whichever field we find ourselves in, we should be very familiar with the professional standard, and always make sure that we are just doing exactly what is required of us to be able to avoid some of these unnecessary and needless claims, which results in, sometimes quite exorbitant liabilities. So I'm sure we'll take the questions later on, and then I'll let them make the slides available for everyone. So if you have any questions, or even after this you have any questions or you want to touch base, then you can even get in touch through the organizers or through our emails, and then we can take it from there. Nettie, or is it? No, it's not Nettie. Madam Asma, was I able to do good by my time?
You took about 20 minutes or so, but that's fine. We learned a lot, so we're really grateful. Thank you very much.
Okay, thank you. So I think I'll end here and then we'll take it up later. Thank you very much.
Thank you very much, Lilian. Kindly note down any questions you have from Lilian's presentation. You can as well leave it in the chat. During the questions and answers session, we'll address every question. You can as well also leave your email in the chat if you want the slides or the recordings of this session. So our next speaker is in person of Raymond Lomo, a dual-trained lawyer and a construction professional with over 16 years of experience in corporate law, construction law, and infrastructure advisory. He is the managing partner of RayAlbert Partners, a full-service law firm in Accra. So, Raymond, please, I'll hand over to you now.
Raymond, we are struggling to hear you. Yes, it's better now.
Raymond is still trying to set up his camera and things, so we're still waiting for him, giving him about 3 minutes or 2 to 3 minutes for him to get back.
Hello?
Yeah, we can hear you, Sir Raymond.
Wonderful, thank you.
Okay.
Okay, so my name is Raymond Dornoh. So the name is Dornoh Theodora. All right, so thank you for your kind introduction. So my job is is it possible to mute everybody so that we don't have a lot of interruptions? Okay, so my job, and thank you very much, Council Geraldo. That was very insightful. And so I believe at this point, we all have a clear understanding of what the legal principles are in terms of professional negligence. So my job is to apply it to the built industry, and for us professionals within the industry, and how we are mindful and use this information in our dealings, in our everyday projects and everyday activities. So Lilian touched on a number of things, and you find that the aspects of negligence that touches or impacts construction professionals goes beyond what our topic, has been slated for, which is professional negligence. And so I will not go into these areas, but perhaps just mention them or highlight them as important areas for perhaps future discussions. Okay, because there's a related thought of breach of statutory duty, which is Parliament's dealings or enactments on various areas of negligence that has been enacted into law. So you find some of the pieces of legislation in the Labor Act, in the Environmental Protection Authority Act. You'll find them in the fire regulations. You'll find them in the Insurance Act. You'll find them in the Disability Act, and so on. Next slide, please. And in the general body of negligence itself, you will still find areas of importance for construction professionals in the evidentiary doctrine of res ipsa loquitur, occupiers' liability, employers' liability, vicarious liability. Lilian mentioned that. Liability for goods, negligent misstatements, which is basically what a lot of us as construction professionals do, because we advise, we supervise, and things like that. Next slide. Okay, so let me just come back and focus on professional negligence. So here, we are looking at consultants and professionals being expected by the law to display reasonable competence in the delivery of their services. As Lilian mentioned, we are not required to be super or experts or special experts or anything like that, but what has been accepted by the body of professionals as a standard, reasonable practice. That is the standard that the court or the law will use as well. So obviously there's duty of care, which we have heard a lot about, required for us professionals. And this duty can arise from contract or from torts. So perhaps our contractual engagements as consultants will arise such duties and obligations. But outside of the contract, we also have, because of the neighbor principle that Lilian talked about, we may have additional duty to our clients, to end users, to the public, to our workers, to visitors, to our sites, and things like that. Okay, next slide. All right, so construction, as we know, is a high risk, high value enterprise, okay? And so it's very expensive to construct anything, any kind of infrastructure projects has quite impressive numbers in terms of how much is required to finance it. And so it's very important that we pay attention to some of these things that can result in cost and liability for us. Okay, so breach of duty of care for us professionals can lead to structural failure in our construction, financial loss, and legal liability, of course. And so this is not just theory, but this is real. So if I should borrow the words of the court in the case of Nocton and Lord Ashburton, professionals are liable for negligent advice in their fiduciary relationships. And this was a case where a lawyer advised a client to the client's detriment, and so he sued successfully. Next slide. So Lilian was kind to share with us some other opinions of where the duty and standards comes from the Architects Act, Section 18.1, and also the Engineering Act. Let me also add that some of our professions are also required by law to register under the Professional Bodies Registration Act, NRCD 143. And in Section 5.2 of that Act, for a professional body to qualify to register under the Act, it has to be a society, an institution of groups, and it's expected that this institution would have its members would be trained and qualified in their recognized profession. What is profession? Profession is what you profess to be competent of. So you stand in the olden days, you stand at the marketplace and say to the whole world, I am a professional in carpentry, I'm a professional in plumbing. All right. And so that standard of the body of people trained with and profess to have that kind of skill and ability is what you'll be accorded to you by law. And that is exactly what this act is saying. And in that vein, subsection 2 says that they have a united common interest in pursuing research and concerned with the progress of knowledge in that profession to maintain code of ethics, conduct among its members, and maintenance of highest ideals of the profession. So when you go through our build industry professionals, you will find that they have code of ethics, they have constitution, they have bylaws, they have regulations, right? All these things are a body of guidelines and specified standards and do's and don'ts for the profession. You find that in the for the architects, in the various GIA regulations and bylaws. You find that for organization of surveyors, you find that for organization of engineering. Next slide. So just to bring it home, let me cite an example from the rules of conduct of members and firms of the organization of surveyors. Part 2 of their regulation states that members shall carry out their professional work with due skill, care, and diligence, and with proper regard for the technical standards expected of them. Again, the members shall carry out their professional work in timely manner as with proper regards for standards, service, and customer care expected of them. Next slide. Okay, so these put together, okay, as Lilian alluded to, if we were to be in court and we are trying to find the standards of care for which somebody is being accused of not meeting, all right, we would piece through all these pieces of legislation and the common law and principles that she has discussed and then measure your conduct by those standards to see whether you fall short of those standards and therefore breaching the standards, and whether there was an injury loss, okay, which is linked to that breach or the causal link, for which we now establish negligence, okay? How would negligence come about for professionals in the construction industry? Ignoring safety standards, for example, poor supervision, defective structural designs. Next slide. For architects, it could come from faulty or impractical designs, failure to consider site conditions, soil drainage conditions, non-compliance with building regulations, poor coordination with engineers and other consultants. So example, you are designing a building without adequate ventilation or structural allowances, or designing without taking account of the proper topography of the place, or doing proper geo investigations to know what is beneath. All right. Now, ground conditions in engineering contracts is always an issue because you never know what to expect. Now, I've been told that when, for example, the Pokwasi interchange was being put together, there was geothermal investigations, okay, because you find that there were piers that were mounted to hold the bridge, and samples taken showed certain average depth that the piers could land on firm rocks to be able to give structural integrity to the bridge. But it turns out that when construction actually started, some of the areas of foundation, the depth or rocks that were required, they had to dig deeper to find the appropriate kind of firm grounds that could hold the piers. So which had cost implications for the contract. All right. Now, this is not really purely about negligence. Sometimes it's just about the fact that you have to make allowance for certain kinds of expectations, and ground conditions tend to be some of these one of the key issues that hamper engineers and the designers' work. Next slide. Now, for structural work, structural miscalculations, inadequate load-bearing designs, failure to inspect works properly, incorrect specifications for materials, and a structural engineer that estimates load leading to cracks or collapse. Now, there has been this debate, especially when I talk to my structural engineering friends about whether to over-design or not. Of course, over-design has cost implications, and for the most part, the clients who always have tight budgets would want that, you know, the designs are not too expensive when costed by a cost engineer. Okay, and so of course, over design is always good because then it can take care of other incidentals or things that you may not, you know, expect. For example, there are ground movements or some other incremental issues that come in that were not foreseeable. But the point is, the money may not be limitless, and so there'll be issues of cost, and the client may want you to design a way that fits budget and things like that. Question is, as an engineer, and that's why we went to engineering school, are you able to redesign and relook at the solution and perhaps consult with others, maybe material engineers and others, and bring their inputs right from the preparation stage and design stage, so that you are able to see how you can still meet the specifications of your client, but you're able to minimize costs in a way that is of value to your client. Now, this week, government has brought a bill to Parliament, value for money bill, specifically for something like this, so that all our public procurement will go to a certain value for money audit or analysis. That happens on our big projects, but they want to incorporate this into the every aspect of our procurement. Okay, if done properly, it helps with project preparation. It helps with proper budgeting. It helps with what to expect and what to know the value exactly that we're deriving from the investments. Next slide. For QSs, negligence can come from inaccurate cost estimates, failure to properly manage project costs, negligent valuation of the work done, errors in tender documentation, and underestimating costs leading to project abandonment or dispute. Because if your cost of the project is say $10 million, when in fact it should be in the region of 15, then you should know that there's going to be problems, because the client will be making available certain financial arrangement based on the cost estimates. All right, and once it exceeds, then there's going to be big problems for everybody down the road. And so surveyors must be meticulous and extra detailed and taking everything into consideration in costing and project, because the client is relying on you, okay, as his cost and financial advisor in making available the funds needed to complete the project. So in the Ghana Institution Surveyors Code of Ethics, they have enshrined in their regulations that a surveyor must undertake to work only within their professional competence. And I think Lilian highlighted that as well, in saying that as for the law would fix on you the standard that is required. It doesn't matter whether you are less experienced and things like that. But the professional guidelines is that when you are being engaged for a job, don't take a job that is above your experience, your pedigree, and your competence. And if that were to be the case, then you should know that you have to bring in others with the requisite expertise and competence and experience to help manage the job, so that you don't get yourself into this sticky situation of being negligent in in the standard that's required of you. Next slide. Now, for project managers, they are basically leaders in the field who must bring together all the experts, all the other consultants, and bring them to work together for the delivery of the project. So poor coordination of these projects can be a source of negligence for a project manager. Okay, failure to monitor timelines and risks, inadequate communication among the key stakeholders, ignoring warning signs of defects and delays, not addressing contractor delays, causing cost overruns. It's definitely a breach of your duties as a project manager. Next slide. For contractors, all right, poor workmanship in terms of material, in terms of skill deployment, all right, can be the bane, can be the basis of negligence, okay? These are substandard materials, failure to follow specifications or drawings that has been specified by the client in the delivery of the project, lack of supervision of the workers, using, say, weak concrete mix leading to structural failure. Next slide. Now, design errors against supervision failure. All right. Now, design errors are fundamental and can be the undoing of any project. So it means that the planning stage of the project is key. All right. Whatever studies needs to be undertaken, whatever investigations that need to be made in the soil, in the environment, whatever needs to be properly done. Okay. This usually is the problem of architects and engineers who design. Okay. Poor project preparations, where you need to undertake, say, pre-feasibility and feasibility studies to give you an idea into what this project entails and is all about, and what kinds of consideration that must go into its design and planning. Where it needs to be taken, it has to be taken. All right. Sometimes a client will tell you, I don't have money for pre-feasibility and all that, but you need to highlight the importance of such an activity to the total success of the project, so that you don't throw money away down the line, okay? Or where you have incorrect calculations, flawed layouts, unsafe designs. And this can affect the entire project and be very, very difficult and costly to fix. Next slide. Liability from certifications and approval. Now, this part is key, all right? Now, work is designed, work has been delivered, all right? There's a process of ascertaining that what is on the drawings, what is being specified, is exactly what is on the ground. That is the process of certification. Now, so that requires surveyors, for example, to go on site to take the measurements, calculate for us to see that the required volumes is really what is in there, the required material strength is what is in there. And so that what is being paid for, it's what is on the site. It's key. All right. So there can be negligence if that work is not properly done. Okay. You have to certify that the work is complete, and you cannot be expected to certify when in fact it is not. Okay. And you have to you have an obligation as engineers, as architects, not to approve when the designs are defective, for example, or issue those payment certificate negligent without probably going to the site to do the necessary measurements and necessary audits and checks. Okay, I've been told that on a very prominent project within the Accra municipality, a certain gradient was required, and so some cuts in the earth was done in order for the road to have to meet the design specifications. Now it turns out that the works had been certified for payment, and a certain area of cut was recorded to be above 2.5 meters of cut of a wide area. Now, somehow the client's engineers were not sure about this this measurement and wanted, which was represented by the consultants, and so they wanted to have a recheck, an audit of the proposed certified works done. And so, in a meeting in discussing this audit, the issue was that, you know, a depth of 2.5 meters of materials have been cut and used to refill other aspects of the project. So the engineer actually stood up in the meeting and said, look, my height is 1.6 meters. Are we saying that there was a cut that's so over almost double my height in the work? I mean, and everyone was like, okay, we have to probably recheck this. Now, when the works was rechecked in this manner, the depth did not even exceed 0.5 of a meter. Now, so just imagine how much money would have been lost to the client if the certificate that has hitherto been certified been paid. All right. So we need to be thorough in our work, especially when we have to put our stamp on work to be paid. So I know that there was an administrative measure in the Ministry of Roads and Highways, for example, where engineers in certifying or signing off on certificates were asked to add their professional stamp. Okay, why are we doing so? We want to say that you own this, all right? If you are saying that this work has been done, then it's on you. You have the responsibility, you're hitting your chest to say that, yes, it's been done and so should be paid for, all right? So this is a very important aspect of project management. And we must take this very seriously so that we don't, you know, expose ourselves to breach of negligence, okay? Negligence or breach of the duties that is imposed on us as construction experts. Next slide. So, architects are required to certify practical completion despite, and so if you do so with despite major defects on the projects, okay, then you're being negligent. Engineers are supposed to approve structural elements, and if the structural elements are unsafe, and you go on to approve, that is being negligent. Or engineers certify poor work, road works, or construction. Okay, I mean we see shoddy works in road construction and bridges all around, and we're asking ourselves, were this certified? Were this paid? Okay, it was usually reported that certain construction works are being re-audited, okay, for payment, because we're not even too sure. Some of it's been reported in Parliament that some of the certificates the works were not even done. There's no work done. The certificates that have been presented for work and things like that. Okay, so we need to be careful. Or a project manager signs off on substandard work, right? That is negligence. Next slide. So let me just take a few examples of where how the law will apply negligence. So in this 1959 case in the UK, there was an arrangement by the defendants, employers, to provide a roof ladder for a worker, okay, to carry concrete up the ladder to the roof Now, this particular employee, he happened to be using oversized rubber boots in doing this activity. Now, the way and manner of transporting the concrete itself is a usual practice within the industry, all right? Which is what the employers have put in place for the carrying or the transportation of the material, okay? But with the fact that it was wet surfaces that he was traversing, and he was wearing oversized boots that were almost twice the size of his legs, okay, he slipped and injured himself. Now, it was established in court that this was the usual practice within the industry of how such material was transported. But the court, nevertheless, felt that it was not reasonable, all right, in providing enough safety, perhaps because of the kind of boots and oversized and the conditions of the environment, how wet it was, leading to the injury. So the court found the employer culpable for negligence, breaching the standards required and the duty that the employer abhorred to the employee. Next slide. In Smith and Bush, this was a survey report by some surveyors, and it was relied by some purchasers of the house. Now, there were some defects in the chimney, and after they relied on the report, which didn't capture the structural defects in the chimney, there was a collapse in the roof where the chimney was, okay? And as a result, what they thought they were buying is not what they got, okay? So they sued the surveyor successfully for the negligent report that they relied on to their detriment. Next slide. In the Ghanaian case of Johnson, Oting Ampofo, and Kofi Joe, another, this case was determined by her leadership, Patricia Kwanzaa, in General Division 6 in Kumasi on the 15th of March, 2024. Now, we're lucky to have such, a case because we don't have too many of our local cases bordering on negligence and especially to do with construction and things like that. Okay, but this case happened recently, and it happened in a suburb in Kumasi called Kasi. Now, the plaintiff here is a contractor who had been engaged by the defendant to put together warehouses. He successfully delivered on the first warehouse, and based on the good work, he was given 2 additional warehouses to complete. One to rebuild an existing warehouse that was deteriorated, and then a completely new one. Now, as part of his work, he was required to build a reinforced concrete retaining wall, okay, to support the warehouses and some other structural works within the vicinity of the warehouses. So the nature of the contract was that it was mainly labor-based. What it means is that the employer was supplying most of the materials, and then the product comes in with labor to provide the building of the structures. Now, the dispute arose because after the contractor had built the structures to a point he considers to be about 85% of completion, the employer stepped in and terminated and sacked the contractor from site, all right, citing incompetence and faulty construction of the structures. Okay, so the contractor sued for wrongful termination and also for the recovery of the amount he has pre-financed in constructing the works. Now, the employer counterclaimed for what he termed incompetent performance on the works and the faulty construction works. Okay. Now, especially for our purposes, we have to look at the counterclaim that claims, and counterclaims are just like a suit on itself by a defendant. So the negligence claim is against the contractor or the plaintiff, that he was incompetent in his delivery of his performance on the warehouses. Now, the court went through the entire proceedings. The evidence was adduced. There was a structural engineer who prepared a structural integrity report, okay, because indeed there was the reinforced concrete retainer walls that were built were next slide, please. Can you go back, please? Yes. There was an auto deflection, okay, in the retainer walls. All right. That showed that was uncomfortable. That showed that, I mean, it could fall down, it could break, something like that. And perhaps that was a complaint of the client or the employer. So he brought in an expert to evaluate and present an integrity report. Now, the integrity report rather found that, as claimed by the employer, it wasn't the case that the contractor built the structures not following his own design specifications, right? That was not the reason why. That he actually did follow the concrete mix, the reinforcement, everything, okay? And that the outward deflection was rather as a result of ground movements, okay? Again, ground conditions, right? Which you can never be able to be certain about, okay? And so it wasn't for lack of or lack of competence in the construction, but it was a factor that had to do with the grounds. And then proposed some recommendations for correcting this. So he recommended an abutment to be built to support the retaining wall. And that's exactly what the plaintiff had done to correct that. Okay. So the gravamen of the counterclaim, which is to say that he was incompetent, he didn't do a good job, was shown not to be the fault of the contractor, and that he actually corrected the recommendations of an expert. So it meant that the employer could not prove the counterclaim. Okay, the counterclaim of negligence against the contractor was not proved, and the court found for the contractor for the wrongful termination and for the recovery of the amount owed by the employer. Next slide. Now, in recent memory in Ghana, we all witnessed or saw on TV the spectacular, rather spectacular but sad Mecom shop collapse, which was carried all over the world. Okay. Some key things I want to highlight from the happening. I couldn't find any official report on maybe investigations or some authoritative investigations into the matter. I'm sure one was done. I'm sure there's some somewhere. If somebody has, please, you can make it available for us to share. But some observations are just made from just a reportage around the event. At the time, the AMA boss was Mr. Oko van der Poel, and he was quick to point out that no building permits had been secured for the development. And so what it meant was that he was sure none of his building inspectors had been there to even cite what was going on there. the vice president of the Ghana Institute of Engineering at the time, Engineer Magnus Kwashi, told the BBC at the time that, I mean, just looking at the debris after the collapse, it showed that the workmanship was very, very poor, and the concrete mix and was not to the specifications that were required for a structure of that magnitude. Okay, it shows negligence right there. Okay, and so when we found out, and it would be catastrophic if the proper considerations are not put in place on site. Recently, we heard about another collapse of a section of a construction near the Ghana Institute of Engineering. We heard that was due to some formwork failure or something like that. These are key safety and other considerations on site. Okay. Again, I've not heard of any reports which can guide the rest of us as to what is not proper, and we all work on sites. We know the proper practices that we need to engage in our delivery on sites and what are substandard. Okay, so to preserve yourself from exposure to negligence, we just have to keep to the right standards, and that brings us to how to minimize risk for you or for us, for all of us as professionals in our projects. So let's look at risk management and practical guidance on how to minimize our risk by way of negligence. How can we protect ourselves? Okay, the first point of call is to work strictly within our professional competence. Okay, and guidance, the regulations. Okay, whether it's the building code, the standards from the Ghana Standards Authority, the national building regulations, our various professional bylaws, code of ethics, and what have you. Let's remain within the standards. That's our sure protection. Follow the industry standards and regulations. Conduct regular inspections and due diligence. Avoid shortcuts or informal approvals. Okay, where there is such approvals, let's make it formal by using the right modes to confirm. All right, whether through email or writing. Okay, something has to be there to show that this approval was given. Okay, next slide. Now, as Lilian rightly observed, documentation is key. Okay, so you have to keep detailed records. Now, here's the thing. When we are awarded contracts, right, or let's say we win a bid or something, there's this initial excitement, right? Because money is going to be made. At least there's work. You can pay staff and things like that. But sometimes we are blinded by this excitement that we don't pay attention and scrutinize and analyze the work that is in front of us properly to know what is required. We assume that, and of course, it may be influenced by some ego as well, that, oh, it's because we are the best, it's because we have the competence and all that. That's why we are winning a particular project. It may not be the case. It may just be that we were the lowest evaluated bidder. And of course, the client was looking at the person who can do it for less. All right. So we may not be the most suited to a particular project, but we may have it, we may get it. Maybe due to our connections, maybe due to it's fine. Okay. Now, perhaps when we get work, we'll be excited, which is natural, but it's also a time to ponder and really reflect on what it is the task is about. Okay, and that puts it in the right frame of mind and perspective, the work that we are going to do. Okay, look inward, reflect inward to see whether truly the competence, the experience that is required to undertake and deliver on this job optimally is there. Okay, if it's not there, there's nothing wrong with that. There are always colleagues, there are always people that you can count on or bring on board to augment the experience, to augment the competence, in order that the work is delivered properly. Let's not just be motivated by profits and excitement and losing sight of the actual work in front of us, okay? So that we're able to have a proper assessment of the work. And once we do a proper assessment of the work and we know what is required, and we have the proper documentation of engineering contract or whatever it is that we sign on to deliver, that's the first step, okay? Then whatever activity goes on, we must document and keep records. Keep detailed records of all instructions, site meetings, design changes or addendums, approvals, certifications. Everything must be well documented and filed away, okay, and kept. That's our protection, okay? If it didn't happen, if it's not documented, it didn't happen. Once it happened, it needs to be documented one way or the other through whatever media that it can be documented in, okay? That is our legal protection. Next slide. Okay. Communication is key on these complex, highly financially sensitive projects and contracts that we are involved in, okay? Ensure that there's a clear written communication between all the parties involved, the consulting team, the contractor, with the client or the employer. The employer may be a sophisticated employer, maybe, for example, government, who may have its own engineers and things like that, right? So there must be proper communication and coordination between the clients and engineers, the consultants, and the contractors, engineers and consultants, and things like that, right? And all verbal instructions must be confirmed in writing, like I said, okay? And report any risk or concerns immediately. Bring them to the fore for discussions, right? Bad communication usually leads to disputes, okay, and problems, okay, which can emanate or lead to claims of negligence against you. So a surveyor must not have undisclosed financial interest in the project they are working on. This is from the code of surveyors, and or have any financial arrangement beyond the normal fees that the surveyor is entitled to, and must fully disclose this in writing. Next slide. So beyond documenting, beyond being careful, analyzing, beyond reporting and communicating properly, the safeguards that you must have, okay, to protect all stakeholders from financial losses as a result of injuries to persons, to property, stemming from mistakes or the care required, is insurance. So insurance plays an essential role on site for risk management, okay? So insurance is typically mandated by law, okay, in contract to guarantee that funds are made available by these insurance houses for compensation in the event of negligence claims, which are common in our construction industry and inherent in what we do on site. Next slide. As a result, sections 183 and 184 of the Insurance Act 2006 requires that insurance of commercial buildings, and that a person shall not construct or cause to be constructed a commercial building without insuring with a registered insurer the liability in respect of construction risk caused by negligence or the negligence of servants, agents, or consultants, which may result in bodily injury or loss of life to or damage property of any workman on site or any member of the public. And any person who contravenes this commits an offense. Next slide. So, on the Ghanaian market, there's a commercial general liability insurance, okay, which is the primary policy for protecting against third-party liability for bodily injury, property damage caused by the insured negligence actions or actions of those they are responsible for, okay? And you find that in various construction engineering contracts, there is a requirement for insurance, okay? All right. If not, you are still better off buying this insurance just to protect you, okay? Then there's a professional indemnity insurance. And this covers negligence in design, errors, omissions by architects, engineers, and consultants. Crucial for claims where professional advice or design falls below the required standards. Next slide. it's proper that you also acquire workers' compensation or employers' liability insurance, which covers injuries to workers and even the injury resulted from a breach of safety protocols. Okay, there's a builder's risk insurance that protects against physical loss or damage to the property itself, that is under construction, which might arise from negligence-related perils like fire, collapse, or vandalism. And then there's a contractor pollution liability, all right, that addresses environmental risks and damage arising from negligence as chemical spills, dust, and things like that. When you go or drive through a construction sites, and those who live around, you wonder, what kind of health risks are being posed. Okay, it's amazing that we don't have a lot of such cases, medical negligence cases coming against contractors and things like that because of pollution. Next slide. Okay, now when these situations arise, when there are claims against us, what can we do? Okay, so the early identification of risk on site is key. Okay, you yourself have to be on the lookout and smell problems and find ways to deal with it before they become big problems and prompt the resolution of those issues. Okay, it is proper to have clear contractual terms in the various contracts that we sign up to in infrastructure contracts. Next slide. When a dispute arises, we are better off engaging alternative dispute resolution mechanisms for our industry. Because as you know, if we go straight to litigation, because of the high risk, high value nature of construction contracts, the delays that it will cause, the disruption, may be cost to everybody. Equipment holding, all the various incidents that you can think of. So it can be costly for both sides. All right. And so if you can explore alternative options of resolving disputes, all right, that is useful to all of us. Now, Lilian mentioned something that is very important that has been developed by FIDIC. So in the recent FIDIC arrangements, there's a DAB and DDAB boards that have been built into the FIDIC contracts, which are standing committees for dispute resolution. And so on projects that employ these mechanisms of contracts, when there are disputes, instead of stopping the project and going to court or going to arbitration and all that, we can engage the DAB or DAAB, all right? The works will continue, and then the complaints or claims can come there to be dealt with while the case goes on. Now that saves everybody. And I think that's a very useful mechanism that should be encouraged across. We have all these resolution bodies that Lilian alluded to: the Ghana Bridges Center, Ghana Institute of Engineering, Ghana Institute of Surveyors, Arbitration Hub. These are all areas, and I believe a lot more will be coming on board to be specialist forums for dispute resolution that can help in dealing more appropriately with claims and disputes within our sector. Next slide. So, for best practices in case of breach of duty, you need to stay professional and objective in the investigation and the discussion of the problem when it arises. Seek early legal advice. Okay? Don't go saying all kinds of things and saying everything to everybody before later on going to run into a lawyer. Okay? Do avoid admitting any liability prematurely. Okay? That's why it's good to speak to your lawyer first to guide you to the process. Okay? And because of the documentation you've been having and documenting everything that's happened, then there's a body of evidence that we can rely on to build our case to your defense and protect you from liability. Next slide. So these are the key takeaways for today's discussion. Okay? So no matter what you do, negligence can still happen at any stage of a project, especially in the complex and the most elaborate ones. Okay, there can be death, there can be accidents, things can happen. Okay, so every professional shares responsibility in this. So documentation, as we have highlighted, will protect you. Communication is key. Okay, amongst all the stakeholders of the project, and insurance is essential in dealing with breach and any resultant liabilities that will come to us. Thank you very much for your attention.
Thank you, Mr. Raymond. So, our time is almost up, so we'll be taking the questions. If you still have questions to ask, you can drop it in the chat box. But for now, I'll be reading out the ones that are in the chat box. So this one is asking, are all professional bodies in Ghana backed by Acts of Parliament? And the second question is, which of them can you say are not backed by acts, and how do they deal with professional? So, Mr. Raymond or Lilian, any of you can answer it.
Yeah. So, not all professional bodies have acts of parliament. So Lilian has given examples of those who have acts of parliament, like the architects, School of Engineering, and Ghana Bar, for example. I believe that medical and dental also have some law, but not all of them. And so those who may not have Act of Parliament establishing them can register as institutions, societies, or groups under the law that I referred to, the Professional Bodies Registration Act, NRCD 143. Okay, and they have legal. They are properly legally structured in law just by registering under that act. The registrar of professional bodies is the registrar of companies. Okay, so it has all the legal backing that is required. I mean, recently I had an announcement by the registrar of companies asking that professional bodies registered under the act to come and do renew and do what is required. You know. So that's what I have. That's my take on it. No, what Lilian has something she wants to add.
Okay, so to add to that, and just this is just by the way, yes, even for us as lawyers, our legal profession act, mandates us to act within a certain degree of legal competence. And it's interesting because currently I even have this matter I am conducting, and one of the defendants is actually a lawyer. And the reason why the lawyer was sued is because hello, can you hear me? Believe that the lawyer did not act within the context of the professional competence that is required of him as under our legal professional. So it does happen, however interesting that is and however that puts me. It's a quite dicey situation, but in this case, it's very manifest the extent to which the lawyer acted negligently. But I want to understand where the question is coming from, so that it wouldn't be the case that we will construe that, for instance, if you are a bricklayer and there isn't a bricklayers association, and therefore no act, requiring of you to act within a certain way, then you cannot be held accountable for negligence. I sincerely hope that's not what you're thinking about, because as I had mentioned earlier in the beginning of, the presentation, negligence arises as a common law relief, right? So, for instance, if you take our Constitution, our 1992 Constitution, Article 11, it lists the laws of Ghana, which includes, by necessary implication, common law principles and stuff like that. So, when it comes to the incidence of negligence, you cannot say that because my profession doesn't have a recognizable body or registered, etc. That can be something you can use as a defense if a claim of negligence is brought against you, or that does not warrant you or give you the opportunity to act so negligently and causing damage, etc. So and I think I mentioned earlier that the negligence as a principle can arise even under contract, which is governed by the Contracts Act anyway, or under tort. You understand? So even if you are a counterparty to a contract, which requires of you to exercise some degree of, diligence or some standard of, of professional competence, right? And you are in breach of that, they can make a case of negligence against you if it is so established. So let's get this right. If you are part or the kind of category that you find yourself cannot be directly, aligned with a professional body, it does not mean that you're exempt and therefore you can go about going with the execution of your work in a way that you deem fit. Negligence, even under tort, can arise from a bystander. You understand? So if, I think Raymond mentioned, with these collapses of buildings and stuff, the Melcom situation and everything, if someone suffers, a bystander or an Okada rider was going by and suffered some damage, you wouldn't say that because of the kind of professional, if you don't have a professional body, so therefore there are no standards and therefore I cannot be held accountable. That cannot be the case. So negligence, the phenomenon of negligence arises just by, at least it's in the Constitution that common law applies. So therefore, whether there is a specific enactment or statute per whichever profession you find yourself, you can still be held liable. So this is the kind of education we expect of you all to take from this session. Thank you very much.
Okay, thank you, Lilian. But with what you just said, doesn't mean someone from the general public can sue a contractor undertaking a government road project.
Yes. And like I said, the things you need to establish, the foreseeability, that whatever you did from which the member of the general public has suffered that injury should have been foreseeable, the proximity. So the proximity, when I was listing the kind of parties, even I mentioned that it can even be between a member of the general public and an engineer or a contractor and a consultant. These claims do arise, right? So it is very possible for that to happen once they're able to meet all the standards that the court is requiring of them, to be able to show that indeed, if you are doing a road project, you do not expect the government of Ghana, who is the one who contracted you, to be the one to use the road. You should foresee that it's a member of the general public that will use the road. And so if you do not meet the design, like Raymond was talking about, the right safety specifications, which will contemplate the ordinary use by the ordinary bystander, then if anything should come out of or as a result of your negligent action, whoever the end user anticipated which is maybe the plantain seller by the roadside, who trips into a gutter and we find out that the gutter was, the design of the gutter was effective or contrary to the contract, which the award that was made by the government to you, then that person can bring a claim against you, rightly so. And so I keep coming back to the takeaway, which is that we should all make sure that in whichever field we find ourselves, we are exercising to the best of our ability the degree or that standard of professionalism that requires, and just doing our work properly. Thank you.
Thank you. So please, the next question, someone is trying to find out what criminal negligence is, and does it apply to construction professionals as well? Any of the speakers can address it.
Okay, so we have to make a distinction between crime and then civil liability. So, and that's where the tort comes in. So in the general sense, right, if there's any injury to a person, like you suffered physical harm, right? There are two, I don't want to be too legalistic, but there are two jurisdictions. We have the civil jurisdiction and then the criminal jurisdiction. If we say civil, it means civilian, it means person to person, it means between two people. So it means that I'm one person, I'm holding the next person accountable, right? So usually negligence as a tort, when we talk about torts, like what I said, tort is like the criminal aspect of civil liability. Tort, the general concept of tort. So earlier I made an example like assault and battery, unlawful arrest, false imprisonment, all those things, they are part of the criminal aspect of the civil liability bit of it. But when we come to crime properly so-called, under the the criminal jurisdiction, it's usually the state that will prosecute you. So it's between the state and the person, state person. And then when it comes to civil liability, You are talking person, 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 person. So the incidence of negligence as a criminal negligence, I'm sure you are just referring to the negligence as a tort, for which ordinarily something that should have been a crime, you could hold a person accountable for it. Do you understand? So for instance, under the normal criminal jurisdiction, we have a complainant who will go and make a report to the police because somebody has assaulted them, which is caused them physical, whatever, within the definition of the Criminal Offences Act. And then the state will prosecute you through either the Attorney General or in some instances, police prosecutor. It's all about injury to the person. But when we come to negligence forms part of the regime whereby you've suffered physical injury, all right, but you can hold a person accountable. So that's the distinction I want us all to understand. So in civil, negligence falls under the civil liability bit of crime in court, and then crime properly so-called under the criminal jurisdiction, we have the state and person, who is the accused person, state and accused. So that's the explanation. I don't know if anyone can touch on that. This is my easiest way of explaining so it doesn't get confusing. Yeah.
Okay, thank you very much, Lilian. So, Mr. Raymond, this question is
All right.
directed to
All
you.
right. Can I just add something to what Lilian said before the question comes?
Okay, that's fine. That's fine.
Okay. Just to answer the person directly, Lilian, well done. But there is such a crime as criminal negligence. Okay. It generally has to do with somebody that has omitted to do something that is so reckless or so negligent that it's considered as a crime, So there is something like that. But otherwise, what Lilian has explained about the kinds of actions that are not criminal actions is what we're actually dealing with in terms of negligence here, or following a bigger umbrella called torts. But as a terminology used by the one answering the question, yes, there is a crime of criminal negligence. That says. So if I can now have my question, please.
Okay, sorry, and then just to backtrack a little, when it comes to the crime, usually it's stipulated in an enactment, so it's not always the Criminal Offences Act that would define. So there are other kinds of legislation, like for instance, I know the ones for the doctors and etc. They actually define certain, certain actions that may constitute crime. So there may be specific incidences of actions that may be defined in these separate contexts. But for purposes of our learning and for purposes of the construction or the design and build industry, this is what we would have to be more conversant with. Yeah, thank you.
Okay, thank you too. So, Mr. Raymond, the question was for early career professionals, that's national service personnel and interns, what are the best habits and safeguards you recommend to avoid exposure to professional negligence?
I think it's a very good question, and well done to the one who asked it. So yes, so I mean, all of us when we were in school as engineering students, and I was a BT student some many years ago, were encouraged to go for internships and then professional, because that's how you can relate to what you're learning in school to the site. And I remember I was at that time I was at Manettville was being developed, Manette Court was being developed, and I was in that company, Madame Biku's company, when these sites were being developed. And there was this particular engineer that I was attached to, and wherever she go, whatever he says, I do. So as an intern and a national service person, your best bet to stay out of trouble is to obey instructions and follow exactly what the experienced engineers are doing. All right? Don't go out of a way to, nothing should let you feel like, you can do something on your own or without the instructions. If you're not sure of something, go and act. That's the whole essence of the exercise of interning okay? But you cannot be an intern and begin to act like you are a qualified engineer or an experienced engineer. So long as you're following what your seniors are doing and you're following instructions, you're obeying them, and when you're not sure about something, you're asking questions, you should be fine. I hope I've answered the question.
Yeah, and just to add to that, as a way of advice, please try and be keeping records and documentation. If it's the instruction from your supervisor is by email, you should take note of it, etc. So that if there's an issue, it's easy for you to, demonstrate that you reasonable, like you are just within your instruction and not beyond or acting out of. You understand? So always try and keep track, even for your learning purposes, for your note taking, keep records of all instruction, when you were asked to do this and by whom and how you were instructed to do such and such and who was supervising and when did you submit or when did you deliver, just to give yourself some degree of protection, assuming things go south. Thank you.
Thank you very much, Mr. Raymond and Lilian. So our time is up. There are a lot of questions to be answered, but we can't answer all of them now. So maybe later they can do a follow-up and find out from our speakers. So at this point, and I'll call in Mr. Charles and Mr. Kumson, the director of Institute, to give us their closing remarks.
Okay. Thank you very much. This has been an insightful webinar. When we did a test run yesterday, Raymond warned me that we could get more than 100 participants. And along the line, we had to open it up to get more people coming in. This has been our highest participant numbers ever since we started our webinars. And we are grateful for you, the lawyers, advising us on this topical issue. We hope we'll be able to organize a second part of this at another time. I know it's deeper than this, and there are many cases you've not even talked about. We hope we'll be able to get a call on you the next time to participate in this webinar. Thank you very much. And to all the participants who came on call, staying on call for all these 2 hours, thank you very much. We'll send you the recordings and the presentations for you also as well. And find a way, if you want to get in touch with the lawyers, if they are willing, we can get you their contact details so that if you have any claim of professional negligence against you, they will see if they can assist you in that regard. So Raymond and Lilian, thank you very much for showing up and assisting the Institute and the Architecture Alliance for this webinar. Thank you.
Thank you. Thank you for having us, Charles. Thank you.
Thank you. It's been a pleasure, quite frankly. It's been a pleasure.
Thank you, everyone, for joining us. We really appreciate it a lot. So for those that left their emails in the chat box, this session was recorded, so we'll share it with you as well. Thank you very much for joining us. See you in the next section. Bye. Thank you.
Nice topic, I'm meeting Andy. Oh, shit. Oh, gosh, Papa. I'm from email into. How professional you listen to about what do